So it's the end of the day, and I know most of you would love to move on for the rest of your evening, but we did want to take an opportunity to talk to you about what we believe is a very dangerous proposal that's moving very quietly through state legislatures. And the challenge is most people don't know much about it at all. There was a good op-ed in the U.S. News and World Reports a couple of months ago to talk about the Article 5 Convention by Robert Schlesinger. And he started with this analogy that I think is helpful when you're thinking about this. Imagine someone told you that they wanted to try genetic engineering on you and that they would try a method that had not only never been tried before, but it essentially involved making up the actual procedure as they went along. Oh, and not only did they not guarantee the results, there was a real chance that while they were playing with your DNA, they may do things that change other things that you had not discussed in advance. But probably not, but there were no guarantees that wouldn't happen. To most of us, that sounds completely crazy. And you might ask, why would you do that? And that, we believe, is the essential pitch by people who want to move an Article 5 convention. So, what is Article 5? Get this to move, thank you. On the screen behind you is the text of Article 5. Article 5 basically articulates the two ways that we can amend the Constitution. One path is for 2/3 of state legislatures to call for a convention to propose amendments to the Constitution, and then a convention must be convened. Any amendments proposed would need to be approved then by 38 states. Historically, though, we've always enacted amendments to the Constitution through the other process that the Constitution provides, with Congress proposing amendments for the states to ratify, and that has served us well for more than 2 centuries. Congress would need to pass an amendment with 2/3 support from each chamber, and then 3/4 of the states would need to ratify that amendment. So that includes the first 10 amendments, known as the Bill of Rights, and the other 17 amendments that Congress has proposed and states have ratified in the last 225 years. Common Cause believes that a call for a constitutional convention to amend the Constitution is dangerous because a convention could put all of our cherished freedoms, rights, and protections in jeopardy. According to legal scholars on the right and left, there's never been a constitutional convention in the nation's history since the original convention that wrote the Constitution. Our next speaker, Walter, will delve into the dangers of a runaway convention, but I wanted to make a few quick points about a runaway convention. If I can get the slide to move. There we go. There's no legal guidance in the Constitution or in the case law for how to run a constitutional convention or rules on how to add up calls for a convention. A convention could write its own rule of procedures. It could set its own agenda beyond the articulated subject of an application and could even choose a new ratification process. No other legal body, including the courts, has clear authority to intervene or set parameters for a convention. There is nothing in the Constitution to prevent a constitutional convention from being expanded in scope to issues not raised by the convention calls. And another issue that we're concerned about is that this would open the Constitution to revisions at a time of extreme gerrymandering and polarization, at a time when we see unlimited political spending by special interests. There are no laws or limits in place that could prevent big money from wooing delegates to a convention. And so we fear it could allow the wealthiest to rewrite the rules governing our system of government. No judicial, legislative, executive body would have the clear authority to settle these disputes about a convention, which we believe would open the process to real chaos. It's also unclear how states would choose delegates to a convention, how states and citizens would be represented in a convention, and who would ultimately get to vote on items raised in a convention. In fact, it's also uncertain whether what the ratification process is. It currently requires 38 states to approve any amendments, but there's nothing to say that a convention, once convened, couldn't say, we just want to use a majority of states instead to decide that. So I wanted to talk a little bit about some of the efforts that are out there to set some political context, and in particular focused on an effort to call an Article 5 convention for a balanced budget amendment. There have been a number of campaigns, but one that has made the most progress is a call for a balanced budget amendment. And in fact, throughout the 70s and 80s, dozens of states adopted calls for an Article 5 convention to propose a balanced budget amendment. Some proponents claim that by 1989 that they had 32 states on record calling for a convention on a BBA. The lack of rules, concerns about a potential runaway convention, and an intensified drive to push a balanced budget amendment through Congress led to more than a dozen states rescinding their call for conventions between 1989 and 2010. However, several conservative groups revived the convention plan and persuaded 11 state legislatures to pass an Article 5 convention call on a balanced budget amendment since 2011. Most convention proponents agree that there are at least 27 live calls for a BBA, a balanced budget amendment convention, and that is just 7 states shy of the votes they need, of the applications they need to move that forward. Who are some of the groups that are behind this? One of them is the American Legislative Exchange Council, or ALEC, which is an organization that most of you know about. It brings together corporate representatives and elected officials at the state and local level who, behind closed doors, work to vote on equals on model legislation. This legislation often benefits the bottom line of ALEC's corporate funders, which include AT&T, Pfizer, UPS, Koch Industries, and many more. ALEC has endorsed several model bills that state legislatures can use to craft an Article 5 convention. One is called the Convention of States Initiative. That would go further than calling for a balanced budget amendment. It would pass applications for a convention to do 3 things. 1, impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and then limit the terms of office for its officials and for members of Congress. The Convention of States Initiative is a project of the Tea Party group called the Citizens for Self-Governance, and Mark Meckler, who co-founded Tea Party Patriots. The model bill has been introduced in 37 state legislatures last year, and many of those carry forward into this year's legislative session. And it's interesting, we've seen a lot of momentum and money going into efforts on the Convention of States. ALEC has also endorsed something called the Compact for America initiative, which would require 38 states to opt into a compact that combines a call for convention, also puts forth convention rules, and the ratification process all into one. That is mainly pushed by ALEC and some conservative think tanks, and is passed in 4 states. The ALEC, Compact for America, and Convention of States and their funders have invested very heavily to try and ram this through state legislatures. But the biggest threat, we believe, is the one on a balanced budget amendment. With just 7 states that they need to get in order to move this, they're within striking distance of moving this issue. And one strategic campaign that they could try is if they can move in a few more states, and for example, it is up in West Virginia this week. It has passed one chamber, it's in the Judiciary Committee. If they did that, they could be at 28 states, but say they get into 30, 32 states, they could then go to Congress and say, and threaten them and say, we're gonna move a convention, and many in Congress are nervous about a runaway convention as well, move an amendment through the other process, through Congress, and send it out to the states for ratification. There are many reasons why economists and other groups that we work in coalition with oppose a balanced budget amendment, but I thought I'd share a few reasons why Common Cause, a good government and democracy reform organization, has been concerned about it since the 70s when it first came up. First, we oppose using the Constitution instead of the executive and legislative branches to determine fiscal policy. We don't believe that the Constitution should be used to delineate an area as detailed and subject to change as fiscal policy. We believe that enforcement of a constitutionally imposed balanced budget amendment would be difficult, if not impossible. Who would interpret the amendment? I think it would be basically left up the courts to do that. And in our opinion, the judicial system is not equipped to weigh in on fiscal policy. It just makes no sense. Another concern is that a constitutional amendment does not allow for flexibility to respond appropriately to sudden changes in the economy, downturns, recessions, depressions, or issues of national security, or crises where there is an immediate response needed by the federal government with FEMA. Finally, we believe that a constitutional amendment would increase the pressure to change budget formulas so that items would be hidden from public view. I know many of you think, well, states do this, they have a balanced budget, and the truth is, in many states, they use gimmicks to hide spending. They could have off-budget agencies, they could have off-budget items, so they don't really balance their budget. But at the federal level, there's much more at stake. If you have an economist, there are hundreds of economists that have opposed this over the last couple decades, and when you have social safety nets like Medicare and Medicaid, Social Security, these things could get very complicated. I should mention also that there are groups on the left that are interested in looking at an Article 5 call for a convention to propose amendments. Wolfpack and Larry Lessig have promoted the idea of overturning Citizens United and implementing campaign finance reforms. Common Cause believes in overturning Citizens United, and we agree with them on that goal. We just disagree in terms of the strategy. We've been working with a broad array of groups to pass resolutions calling on Congress to overturn Citizens United, and we've seen some real success in that. We've moved that in 16 states. There may be 2 more states that move that this year, and also in 680 municipalities. So next, I'm going to call up Walter Olson to speak, and I'd like to introduce him to you. He's with the Cato Institute to talk about both some of the legal issues and concerns about a runaway convention, and also the bipartisan nature of concern around a constitutional convention. Walter is a senior fellow at the Cato Institute Center for Constitutional Studies. Prior to joining Cato, Olson was a senior fellow at the Manhattan Institute. He's been a columnist for Great Britain's Times Online as well as Reason. His writing appears regularly in the Wall Street Journal, New York Times, New York Post. He's appeared numerous times before Congress and has approximately 400 broadcast appearances. You name the outlet, he's appeared on it. He's also written many books, including Schools for Misrule, Legal Academia, and an Overlawyered America, The Rule of Lawyers, and The Litigation Explosion. On the web, he continues to run a blog called overlawyered.com, which is widely cited as the oldest blog on law, as well as one of the most popular. So, Walter?
Thank you, Karen. And I wonder if we can get this back to the actual text of Article 5, because that's the perfect thing to have on the screen. I'm a textualist and an originalist, just like Justice Scalia on this, and you know what he thought of it from the blurb that was up there. He said it was a terrible idea. Let me start by outlining a little bit more of the politics, because the politics of an Article 5 convention keeps changing, and One significant development, of course, was the emergence of the effort to get one to overturn Citizens United, which has brought in a very substantial amount of enthusiasm in state legislatures from more or less the political opposite side of the balanced budget amendment. But there is also much more going on what you might call the conservative side. And a lot of this traces back to a book called The Freedom Amendments, done by a talk show host named Mark Levin, who may not be very familiar name in this room, but is a very, very popular talk show host. And he has broken from the old balanced budget recommendation in a significant way, in that he wants a suite of different amendments. He wants substantial structural changes, particularly in the balance between state and federal power in the Constitution. Now, this was out there as a popular grassroots idea for a few years, making a lot of headway, and within the last 6 months or so, a couple of major additional things have happened. Marco Rubio, presidential candidate, came out for, and I call this turning a runaway convention from a vice into a virtue. They say, well, you warned of a runaway convention, let's have one. Let's put every different idea on the table. And Rubio proposes a bunch of things, term limits for both Congress members and members of the Supreme Court. Barely had Rubio come out with his press comments on that when the governor of the state of Texas, Greg Abbott, a well-known figure who's been around for quite a while, came out with a long and intensely researched report calling for essentially an organized runaway convention, a convention in which explicitly everything would be on the table. And he started off the bidding with the so-called Texas plan of 9 basic categories, all of which would return power in some way from the federal government to state governments. As a libertarian, I kind of liked some of the ideas in there. But what was interesting was that Abbott didn't view this as the last word. He said, this is our Texas plan. Every other state, please bring your own plan. And as I warned some of my libertarian friends, there is going to be, should Abbott's idea go forward, there's going to be a New Jersey plan which rolls back the Second Amendment to allow more gun control. There is going to be a national security should gain ground on the First Amendment plan from some state that is worried about terrorism, in which we surrender more of our First Amendment rights or our Fourth Amendment rights so that the government can better protect us, or at least argue that they better protect us against terrorism. And on down the line, there will be a California plan. I really scare them when I say that. There will be all the ideas from left and right and ideas that we can't even imagine because, let's face it, when people think big, they tend to think constitutional. And so we have taken years of criticism from skeptics of the convention saying, but might there not be a runaway convention? And we've created a movement saying, yeah, let's go, let's have a runaway convention. And I'm not reassured because I think that all of the original worries about a runaway convention are there. Let me get back for a moment to the procedural ones because in a way they are the likeliest place for the ship to sink. We know that Congress is keeping tabs on a list of what states have called for a convention. We know also that the calls do not have identical wording. As this has gotten more serious, of course, there have been attempts to coordinate on exactly identical wording. But someone in Congress, and this is perhaps the only point at which Congress will have a lot of power in the process, has to decide what is close enough. First, what is close enough in language? If 2 states both clearly want a balanced budget amendment, but they've used different language, does those count as the same call? In aggregating these numbers, you also have to worry about what we call contemporaneity in the amendment wonk business, which is, are the calls close enough together in time? If someone called in 1972 and someone else called in 2016, and the first state in the meantime has completely changed the complexion of its politics, is it safe to say that it is the same call? Well, here you have the first place for a possible constitutional crisis because you have the entire range of different views from the way that Congress might be tempted to act. Since all these things take power away from Congress, they might be tempted to say, no, absolutely every T has to be crossed in the same way. We will give no margin whatsoever, at which point you have potentially great public frustration. Look, they are just pulling technicalities on us in order to keep us further and further from the goal. Or you could, on the other hand, have a Congress elected by populists one year that likes this stuff and put the English on the ball in the other direction and took, there is nothing in that text, I'm sorry, I just accidentally changed the page. There's nothing in the text you saw until a moment ago that specifies whether the calls need to be on the same topic. And people have assumed that they do, but you can't find the language. It does not say that they need to be relatively contemporaneous. Again, we assume that they probably do, but you can't find the language. What about rescissions? And Karen, of course, was talking about rescissions. Now, there's a little bit of precedent on rescissions, because if you remember the Equal Rights Amendment fight some years ago, that bogged down without being able to get the requisite number of states to ratify, and then a few states began passing rescission resolutions. And you had exactly the two issues I've been warning about. First, you had contemporaneity. Conservative opponents of the ERA said, no, too much time has elapsed. But you said you had various advocates of the ERA saying that rescissions shouldn't count. Now, everyone who is still around from that debate will find that the words get reversed in their mouth because the people who wanted to count rescissions then might not want to count rescissions in our next crisis, and vice versa. The fact is that we don't have a Supreme Court ruling on this because it's all new. So let's say that Congress somehow manages to reach a consensus as to when the number has been triggered. You will hear from advocates of these various schemes that they've learned their lesson. They're not just going to send people with a one-way ticket to Philadelphia. And they figured they learned their lesson when the last convention in Philadelphia ran away. And instead, they're going to give them very tight marching orders, both on the topic of convention and also on various procedural things. And they've made a good faith effort. I don't think it's enough, but they've made a good faith effort through things like the compact to coordinate on identical instructions. And you bring up the issue of the faithless elector. Many of you know that one of the issues with the Electoral College, which we were hearing about a few moments ago, is that although you think electors are bound to vote for the candidate they were elected for, sometimes they don't, and then nothing happens to them. They go back to private life, and they've just cast a vote other than the one that the voters expected of them. And again, I look at that, and I see absolutely nothing binding the attendees at a convention. Some states purport to have criminalized being a faithless convention member. I don't believe for a moment that that's actually going to stop the populist winds from blowing on that. So you've got uncertainties here which will cause very severe political stresses. One of the other things that is not specified there is whether or not larger states get larger delegations to vote at a convention. We know that going into the process and coming out, in calling for it through 34 states and in ratifying it through 37, the small states get the best of the bargain. They get what small states wanted out of the Constitution, which is a blocking right to make sure nothing gets done. And yet the structure of our Constitution is a constant balancing between the blocking rights of small states and the chance to provide forward momentum that large states want and usually get in our constitutional structure. It will reliably be argued by the Californias and New Yorks of the world that despite the equal state representation at the beginning and the end, in the middle when they're voting on what content to have, larger states should get larger delegations. And that won't be easy to resolve. I keep talking about the unresolvable issues because the way you drift into a constitutional crisis is if two halves of the country disagree on, let's say, who is the legitimate president that has been elected, or on whether the Constitution really does include clauses N, O, and P. And that's very possibly something that could happen here because I've talked about how the conventioneers can't really be bound. The states, there's no language in there giving either the states or the US Congress the right to bind them. To the extent that anyone can rule on it, it's probably the Supreme Court. The Supreme Court has the legitimacy and the interest in doing so. My next question is, when does the Supreme Court rule? Supreme Court does not give advisory rulings, one of the basic elements of our judiciary. And as a result, you go through years of national tension, enormous, only to find out at the very, very end of the process, nope, you didn't follow the right procedures. This is all null and void. So especially for my friends who love the content of the different amendments, and I love some of them too, I warn them, if it doesn't blow up like the Coyote's Acme processes, it's likely to just sit there and do nothing, and you will have wasted a lot of your time. Thank you.
The last thing I wanted to do is just show you a little bit about the state of play and a map of where we are. So as I mentioned before, we see the biggest danger is efforts to enact a balanced budget amendment with 27 states on record and West Virginia looking quite likely that they could move it there. One of the challenges is, let me just share with you some of the top targets to move a balanced budget amendment this year. Arizona, Idaho, Oklahoma, Montana, South Carolina, Virginia, and Wyoming. This is a stark landscape in terms of the support that we see for moving this. And let me tell you a little bit about what it's like on the ground. We do have a coalition of many different groups working with the Center for Budget and Policy Priorities, and they're groups that look at fiscal and budget issues. There are groups, AFSCME and others, SEIU and others that have worked on this, good government groups like Common Cause. One of the challenges is many of the allies on the ground that are battling this are also fighting on many other issues that are top priorities. And in many ways, this is no one's top priority, except for some of the groups and the grassroots groups that are funded by ALEC and others who spend a lot of time and attention on this. So what we're facing in states is that many of our state groups say, well, so we lose it here, someone will stop it along the way. And they've been saying that for a while, and here's where we are. With just a handful of states between us and a possible call for an Article 5 convention. So the other thing that I neglected to mention, which I think is worth mentioning, you know, one of the things, and we've seen, we're monitoring the work of Compact for America, the Convention of States. One of the things with the Convention of States, their public communications, even though they talk about focusing on fiscal issues, we've seen them talk about overturning Supreme Court decisions on marriage equality, on health care, on fair housing, and many other issues. So the plan for them is not just to keep this narrowly focused on fiscal issues, but really look at those that are much broader. So I wanted to encourage any of you that are interested in being involved in this to, one, look at this report, The Dangerous Path by Jay Riestenberg at Common Cause. And also, I wanted to, where is Jay? Is he here? He's back there in the back. And also, I wanted to call out Alex Rugoff from the Center for Budget and Policy Priorities. We are trying to get help on our West Virginia fight, so connect with either one of them. And we have copies of the report in the back of the room, as well as one of the many pieces that Walter has done, the Wingnut Plot to rewrite the Constitution. So that's in the back as well. So thank you so much for listening to us, and to the extent that any of you are interested in learning more about this, please see Alex and Jay in the back of the room. So thank you. I think we can go down. I think they're just going to